Welcome to the Supreme Court of the United Kingdom. Today, we're handing down two judgments. I'm Lord Leggatt, and I will be giving a short summary of the first judgment to be handed down in the case of Uber BV and others against Aslam and others. I'll be followed by Lord Briggs, who will be summarising the judgment in the case of Evergreen Marine UK Limited against Nautical Challenge Limited. The main issue on the appeal to the Supreme Court in the case of Uber BV against Aslam is whether an employment tribunal was entitled to find that Uber drivers are workers for the purpose of employment legislation, which gives workers the right to be paid at least the national minimum wage, a right to annual paid leave, and certain other employment rights. The definition of a worker in the legislation includes anyone who's employed under a contract of employment. It also extends to some people who are self-employed. In particular, it includes an individual who, even if not an employee, works under a contract whereby the individual undertakes to perform personally any work or services for another party, provided the other party is not a client or customer of the individual. A person who works as an independent contractor performing services for his or her own customers is therefore not a worker. Uber BV owns the technology behind a smartphone application, which anyone who wants to book rides through the app can download to their smartphone. Its subsidiary, Uber London Limited, is licensed to operate private hire vehicles in London. To use the Uber app as a driver, an individual must be approved to do so by a local Uber company, licensed to operate private hire vehicles, in this case, Uber London. The claimants, Mr. Aslam and Mr. Farah, were licensed to drive private hire vehicles in London and did so using the Uber app. Their claims were brought as test cases in an employment tribunal to determine their employment status. At the time of the tribunal hearing in 2016, there were around 40,000 Uber drivers in the UK, of whom around 30,000 were operating in the London area. The Employment Tribunal found that the claimants were workers who worked for Uber London Limited. This decision was upheld on appeal by the Employment Appeal Tribunal, and again by a majority of the Court of Appeal. On its further appeal to the Supreme Court, Uber maintained its case that drivers are independent contractors who work for themselves and not for Uber. Uber argued that when a ride is booked through the Uber app, a contract is made directly between the driver and the passenger, under which the driver agrees to provide transportation services to the passenger. Uber's role is simply that of booking agent. The fare is calculated by the app and paid by the passenger to Uber, which deducts part of the fare, 20% in these cases, and pays the rest to the driver. Uber describes the amount deducted as a service fee charged to the driver for the use of its technology and services. To support its case, Uber relied on the wording of its standard written contract terms, to which drivers and passengers must agree before they can use the Uber app. Uber also emphasised that drivers provide their own vehicles and are free to work when they want and as much or as little as they want. The Supreme Court unanimously dismisses Uber's appeal. My judgment, with which all the other members of the court agree, outlines the proper approach to determining whether or not an individual is a worker within the meaning and intent of the relevant employment legislation. The legislation is intended to give certain protections to vulnerable individuals who have little or no say over their pay and working conditions, because they are in a subordinate and dependent position in relation to a person or organisation which exercises control over their work. The legislation also prohibits employers from contracting out of its provisions. Applying the test of a worker in the light of the legislative purpose, the Employment Tribunal was justified in finding that the claimants were working for and under contracts with Uber. My judgment emphasises 5 aspects of the Tribunal's findings, which in particular supported that conclusion. First, where a ride is booked through the Uber app, it is Uber that sets the fare, and drivers are not permitted to charge more than the fare calculated by the app. It is therefore Uber which dictates how much drivers are paid for the work they do. Second, the contract terms on which drivers perform their services are imposed by Uber, and drivers have no say in them. Third, once the driver has logged onto the Uber app, the driver's choice about whether to accept requests for rides is constrained by Uber. One way in which this is done is by monitoring the driver's rate of acceptance and cancellation of trip requests, and imposing what amounts to a penalty on the driver if too many trip requests are declined or cancelled. This consists in automatically logging the driver off the Uber app for 10 minutes, so preventing the driver from working until allowed to log back on again. Fourth, Uber also exercises significant control over the way in which drivers deliver their services. One of several methods mentioned in the judgment is the use of a rating system. After each trip, the passenger is asked to rate the driver on a scale of 1 to 5. Any driver who fails to maintain a required average rating will receive a series of warnings, and if their average rating does not improve, will eventually have their relationship with Uber terminated. A fifth significant factor is that Uber restricts communications between passenger and driver to the minimum necessary to perform the particular trip, and takes active steps to prevent drivers from establishing any relationship with a passenger capable of extending beyond an individual ride. Taking these factors together, the transportation service performed by drivers and offered to passengers through the Uber app is very tightly defined and controlled by Uber. Drivers are in a position of subordination and dependency in relation to Uber, such that they have little or no ability to improve their economic position through professional or entrepreneurial skill. In practice, the only way in which they can increase their earnings is by working longer hours while constantly meeting Uber's measures of performance. For these and other reasons set out much more fully in the judgment, the Employment Tribunal was right to find that Uber drivers are workers who therefore qualify for the rights conferred on workers by employment legislation. The judgment also upholds the finding of the Employment Tribunal that for the purposes of the legislation, the claimant's working time was not limited, as Uber had argued, to periods when they were actually driving passengers to their destinations. It also included any period when the driver was logged into the Uber app in the relevant territory and was ready and willing to accept trips. And that concludes this judgment summary.